Welcome to the Sui Generis Show, your unique perspective on everything you need to know about your civil rights and the criminal injustice system. With Erica Merrill, I'm attorney Brian Jones, criminal defense and civil rights warrior. Today in segment one, we'll be discussing the discrimination lawsuit brought by a dozen Columbus police officers against the Columbus Police Department. We're going to catch up on the civil rights lawsuits that have been filed against Bill Cosby following his release from prison. And we're going to be looking into the investigation of Florida Congressman Matt Gaetz. In segment two, we're going to be exploring the age-old question: why did this officer seize drugs but not arrest the driver of the car? To make sure you don't miss an episode, subscribe on Apple Podcasts, Spotify, and YouTube. Look to the law office of brianjones.com and all of our social media outlets for everything you need to know about your civil rights and the criminal injustice system. So, Erica, did you see in the news this week, Columbus police officers have taken the first step towards a federal discrimination lawsuit against the city of Columbus and the Columbus Police Department?
Yes, I did. And I'm sure that you could see this coming from a mile away. It's going to be really interesting to see how they fight back in this vein. What steps have been taken?
An inquiry has been filed with the Equal Employment Opportunity Commission. Now, the EEOC is a federal agency that was established in 1964 as part of the Civil Rights Act. Its role is to administer and enforce civil rights laws against workplace discrimination. So the EEOC will review the inquiry and either launch its own investigation or give the officers the right to sue in federal court. Now, right now, there are 11 parties to the inquiry, 10 officers and a sergeant, but more could join the group as the investigation proceeds.
I mean, that's really interesting. So they're trying to add people to the suit. And I suppose that's a good strategy. So why can't the federal court consider the complaint before or instead of starting with administrative hearings?
The Civil Rights Act established administrative procedures that have to be exhausted before a civil suit can go forward. And those administrative avenues are really important because they offer remedies that can be better implemented by the agencies rather than trying to get those results through court enforcement. For example, the EEOC can work with the employer, in this case, the Columbus Police Department, to reach a resolution through mediation if they are cooperative. Now, otherwise, the EEOC can launch their own investigation that can include on-site investigations, interviews, depositions, subpoenas, and these administrative remedies can include consequences for the government agencies, including fines, back pay to the aggrieved individuals, job reinstatement, promotions, and things like that. Attorney's fees and court fees are also awardable by the EEOC. And all of this is done without filing a lawsuit in court because litigation is expensive and it takes time. The administrative process can be a bit more streamlined. It reduces the costs to all of the parties and therefore the costs to us citizens, because remember, we're talking about a government agency being sued here.
Thanks for that explanation. That's really interesting. Can you tell us, why is the identity of the plaintiffs important?
In this case, the parties are men and women of a variety of ethnic and racial backgrounds. And I think this is significant because it reveals a broad cultural issue in the Columbus Police Department that was witnessed by a variety of people, regardless of their particular background or identity. We're not talking about one particular group that's being discriminated against. It seems like it's discrimination across the spectrum of minorities. And the parties allege that they have been victims of discrimination, and in some cases, even retaliation for reporting discrimination. So it seems like there's a cultural problem in the Columbus Police Department, and that's the thrust of the complaint to the EEOC.
That's really interesting. Can you tell, what are your personal thoughts on this? Because I know that you stand up against discrimination all the time, but the police are often the ones that are doing the discriminating. And now this lawsuit is coming up where they are saying they are being discriminated against. just curious about your personal thoughts.
Personally, I think this is another example of needing to hold the police to the same standard that we hold everybody else to. I have railed throughout the entirety of the existence of this podcast about the fact that police feel that they're above the law, that they don't have to follow the rules that are set forth for every other employer, both public and private, every other person, both public and private, that are enforced across the board in the United States. I applaud these complainants for holding the Columbus Police Department and their supervisors to the same standards that you and I have to hold, are held to ourselves.
I agree with you. So, I mean, I think we'll have to keep our eye on this and see what happens, but certainly everyone should be treated the same. I'm glad that they're making an example of it.
Absolutely. And continually across the nation, an example must be made of law enforcement agencies, because if they aren't held to the standard, respect for law enforcement goes down and police officer jobs become more difficult. So holding other officers accountable, rooting out and tossing out the bad apples, because that's the story that they want to believe. It's not a systemic problem, it's an individual problem. So if that's the truth, then those bad apples out and toss them out of the department. Now, another story that is continuing to develop and about holding people accountable, Bill Cosby is back in the news as he invokes the Fifth Amendment due to fear of new prosecutions.
This continues to be such a confusing situation to me. I know, and you explain it so beautifully, but wasn't Bill Cosby just released from prison because he can't be prosecuted? I thought we just went over that.
Yeah, so he can't be prosecuted in Pennsylvania state court because of the agreement that was reached with the Pennsylvania, the district attorney back in the 2000s. Now, that only addresses charges covered by that state jurisdiction. Cosby can be prosecuted in other states, and he can be prosecuted by the federal government. He can also be a defendant in civil lawsuits. So the litigation train is going to be ridden by Bill Cosby probably for the rest of his life.
I mean, it sounds like it. I'm really interested to know, like, what is the difference between the defense he was getting, and now this is going to be the defense of a civil case? Can you raise the Fifth Amendment in a civil case?
Yes. So the Constitution, the words of the constitutional amendment refer to criminal proceedings, and the right to remain silent and not be a witness against yourself applies in a criminal context. But the courts have found that it applies to any other context in which a testifying person could incriminate themselves, or their statements could be used against them later. Remember, an incriminating statement isn't just a confession, but it can be a variety of statements that go to the outer edges of the theory of a case that police and prosecutors may be trying to put together. And in this particular context, we're talking about incriminating evidence that would likely support the criminal allegations of sexual assault and might furnish a link in the chain of evidence that could lead to prosecution, as well as evidence that an individual believes that they could use later against him or her in a prosecution. Now, that's language specifically from a United States Supreme Court case called Maness versus Myers. Unlike in a criminal case where the silence of the defendant can't be used, though, in a civil lawsuit, if you invoke the Fifth Amendment, then the other party gets to use an inference, a negative inference, that the answer to that question would be bad for you. So if you say, I raised the Fifth, then the other party gets to say, yeah, because anything you say would either be a lie or would make you responsible for what we're alleging against you.
Wow, that is really interesting. So do you have to actually be guilty of something to raise the Fifth Amendment in a defense?
Absolutely not. The Fifth Amendment protects the guilty and the innocent equally. The distinction between civil and criminal interpretations of this rule and exercising the Fifth Amendment really reflects the difference in the severity of consequences. Civil cases result in fines and orders to act in a particular way, such as injunctions, forcing you to refrain from engaging in speech or giving up land. But in criminal cases, the consequences are your freedom. And so the stakes are much higher. Civil cases are resolved through damages and the exchange of money and are supported by a policy goal of resolving the conflict in order to facilitate social cohesion. We want to make people feel better so that society can keep going on. So that the Fifth Amendment can be raised even by the innocent because it's easier to give somebody money than it is to give up your freedom. It's less of a severe consequence.
I mean, I would tend to agree. I'd rather give up money than my freedom for sure. Well, I mean, so thanks for letting us know about this. And I mean, it sounds like this is going to be something that we can follow for quite a while to see all of the different things that happened in this Bill Cosby case.
It's absolutely going to be a saga that's going to continue for years to come, and honestly probably out-survive Cosby himself, as his estate will continue to go through these civil suits long after he has passed.
I mean, that's really interesting that you say that. I'm just curious, has that happened with a lot of famous people where they have a lot of lawsuits? I mean, I guess Michael Jackson, and anyone else you think of?
Well, Michael Jackson is the one that comes to mind, but anybody who passes away during the pendency of a civil suit, that civil suit will then add their estate as a defendant in that process. Or the same goes for plaintiffs. If a plaintiff passes away during the course of a civil suit, their estate can continue to prosecute that civil suit in their name to its conclusion.
Wow. It's great. Thank you so much for letting us know about that. That's very interesting.
Absolutely. And somebody that's on the very threshold of that journey through what is likely to be years, if not decades, of civil lawsuits and potential criminal prosecution is Matt Gaetz, the Florida congressman. And he is now being exposed by his wingman, who has turned over to federal authorities years of Venmo transactions and thousands of photos and videos of him engaging in sex acts or pursuing children to engage in sex acts.
That's really crazy. But like, why wouldn't the investigator subpoena the records?
Subpoenas can always be pursued for these kinds of records when they're in the jurisdiction of the United States. Now, some of these records may be offshore, but there's also a benefit of receiving this kind of information from a cooperating witness because it provides context and relevant material that comes with an authenticating witness and somebody that can explain the evidence in question. While police officers can issue search warrants and subpoenas for digital evidence, a sophisticated user might know how to hide that information from law enforcement, from the service providers, and receiving the accused own digital files, their own photographs, their own Venmo records from a person that was directly involved with those transactions is incredibly valuable because of the easy authentication and the context that it provides. It creates a major problem for the person that's being accused.
How does the digital evidence affect the defense of potential charges?
Digital evidence provided by someone with personal knowledge and a direct connection to the accused can be challenging because the cooperating witness can identify how and when the record was created, that is separate and apart from the metadata that's contained in that digital item. That person can also testify to the fact that the accused did in fact receive and send the information based on how the accused responds and behaves, both in real life and in the digital world, again, as context around that message. Now, for the defense, a thorough analysis of the metadata is critically important to challenge authenticity, to see if this information is actually from the defendant or the accused's phone or other device, and provides a variety of avenues to attack the reality, the authenticity of this information. And an accused person can also consider their own digital evidence and their conduct around the digital evidence. So understanding, based on metadata, where was I? Who was I with? Who was around? What was my behavior this day? What sort of state of mind was I in? So that they can provide context and information to the statements that were made. I think anybody who does a thorough introspection of the things that they post online, the text messages that they send, would have to come to the conclusion that if you took some text messages out of context, one line out of an entire text message thread, or even a few lines out of a text message thread, they may appear very damning. Frequently, if you scroll through your Venmo feed, you'll see the joking, they've got the little reason why you sent the money. And sometimes people will say, wink, wink, eggplant emoji, or something like that in a juvenile joking situation. Well, without context, that's going to be very damning. It's going to appear very damning to the accused. But when the accused partners up with a well-trained attorney, then the accused can provide that context and explain how, well, this was a joke. This is something that we talk about back and forth. Is it in poor taste? Probably, but it doesn't mean what you're trying to say that it means.
I mean, that's very interesting. I mean, in that way, Venmo is a lot like social media, and you should really be careful what you're posting. I mean, so, and I'm sure that you're going to see this more and more. Venmo is a lot newer than a lot of the social media platforms. So is it significant that the congressman and the cooperating witness were very close friends?
Well, I think it is. And I think it is in a couple of contexts. First, a close friend can be seen by the trier of fact as somebody who's very credible, because they had the opportunity to see and observe the person that they are now accusing. And they understand that person's language. They have experience with how they talk. They have experience with what is a joke to them and what is not a joke to them. Second, a close friend is likely to know intimate details about the accused and other acquaintances, and can not only provide this direct information, but derivative information, more leads for law enforcement to chase down. Last, and certainly not least, from the defense perspective, that close friend has now betrayed the accused person, and they are now a snitch for the government. And so, why is this person stabbing the accused in the back? It leaves them open to a variety of attacks on cross-examination, both in a courtroom setting and in the public eye, that may ultimately backfire by leaving the friend uncredible.
I mean, that's why you need to have a great attorney. And I'm sure that you've helped defend a lot of folks who are in similar situations, probably more on the social media side. And I know Venmo's creeping in. Have you seen this a lot recently?
The use of Venmo for criminal purposes, or for maybe fringe purposes that are kind of in that gray area between criminal and non-criminal behavior, has become ubiquitous at this time. And really, for the people that are less sophisticated, the reality is that the more sophisticated criminals are using things like Cash App, are using Bitcoin transfers in very small amounts to make those transactions untraceable. Venmo will share your transactions with authorities upon request. And then, of course, it's in a public feed there, right there in the Venmo app. So those transactions, while some of the details are hidden, are largely publicly available. That's one of the appeals of the Venmo platform, is that you can see what your friends are doing and what they're spending their money on. So I think the less sophisticated criminals are using Venmo, but the more sophisticated criminals are using a variety of other platforms to exchange funds.
I mean, hey, that's just a lesson to the folks out there listening. Make sure your privacy settings are set correctly if you are using Venmo.
Absolutely, Erica. And your privacy is of the utmost importance. And it's not just for people who are actually engaging in criminal behavior. Let's remember, Matt Gaetz says that he has done nothing wrong. Matt Gaetz is today an innocent man, but certainly his inability to maintain appropriate privacy settings has exposed him to significant scrutiny. And whether he comes out of this without stain, or he ends up in a situation similar to Bill Cosby, having been convicted and then exonerated and then facing civil lawsuits, remains to be seen. But remember where it all started with, which was a failure to protect himself and assert his privacy on the part of Matt Gaetz. Now, people that are driving down the road also think that they have privacy in the contents of their car. But of course, Erica, you and I both know that that's not true. And with probable cause, police will pull over, search, and seize items found in a vehicle. Now, sometimes the items that are seized from a vehicle will include drugs like marijuana, cocaine, or heroin, paraphernalia like smoking bowls and syringes, or baggies that have mere residue in them, pills and pill bottles. But the officer might not issue a charge or take the occupants of the car to jail at the time of the stop. Today, let's explore why that is in our deep dive.
Yeah, this is going to be really interesting. I know that a couple weeks ago we spoke about being careful who you let in your car, because you could get in trouble for what they have with them if you get pulled over. But why would an officer seize marijuana without issuing a charge? Is he smoking it with his friends?
It's possible. It's not out of the realm of possibilities. But more likely than not, it's going to depend on a couple of circumstances. And with marijuana in particular, because it is moving so close to not only decriminalization, but full legalization, officers are less and less pursuing actual charges for even contraband marijuana. So Ohio being a medical marijuana state, but flower or raw marijuana is not something that's legal. Officers are still kind of going down the path in a lot of circumstances of just seizing the drugs and not issuing charges. So that is a discretionary choice that each officer can make, to just seize it, put it into evidence, have it destroyed, and never issue charges. If we're talking about larger amounts of marijuana, amounts that exceed, the 100-gram threshold, that is the difference between a minor misdemeanor citation and, criminal charges that carry the potential for jail time, the officer very well may seize the drugs and not issue a complaint in that moment for a variety of reasons. One is the substance has to be tested. Two, the substance has to be weighed. Three, because that weighing and testing has to be completed in order for them to prove their case, if the charge is issued and if the person then goes to court, speedy trial time starts to run on the government. So, these factors go into deciding whether they're going to issue a charge right now, or whether they're going to go get their ducks in a row at the lab and then come back and issue charges later. Marijuana derivatives are kind of graded in a similar way. So less than 5 grams solid or 1 gram of liquid is, again, a minor misdemeanor. And as we go up the scale with those derivatives, like the pipes, the vape pipes that people have, or hash oil, or dabs, those increase in consequences as well with the volume, the weight of the substance that's found. But again, a little chunk of wax may or may not be a controlled substance. So the officer may make a decision, I'm going to seize this substance, send it off to a lab, and have it tested before I issue charges, so that, one, I do have evidence, and number two, that speedy trial clock doesn't start running. Erica, an officer doesn't have to issue charges for any conduct that he or she witnesses for a statutory period of time. And I think we've probably all heard of the statute of limitations, or as Ohio calls it, limitation of actions. And that statute puts a time limit on how long an officer or anybody has to bring either a criminal or a civil lawsuit. In the case of a minor misdemeanor, that possession of marijuana that's less than 100 grams, the officer has 6 months to file that charge. On higher level misdemeanors, 2 years. And for most felonies, 6 years to file those charges, to even initiate the court process. So those charges don't have to be filed right there at the roadside. They can come much later in the process. So if you have been stopped and if you have had items seized, you need to reach out to an attorney immediately, and don't wait until those charges come, because what often happens is the charges are issued to a wrong address. Then you don't receive the charges. Then you get a warrant. Then you end up getting arrested and spending a night, a week, several weeks in jail waiting to get your court date, because the court considers you an absconder, even though you didn't do anything wrong.
I mean, too, it sounds like that's really strategic, in that possibly they can hold that over your head to get ahead in something else that they might want later on. Have you seen that?
Absolutely, Erica. I've seen officers use that sort of Damocles hanging over an accused head for leverage to try and get them to become a snitch. And I've even seen I've seen officers hold charges for months at a time and then file them at the last minute and immediately issue a warrant, especially in cases of minor misdemeanors. There was an officer here in Marion, Ohio, who I think had some racial motivation in holding off filing charges for 179 days. Now, that's my opinion, but he did wait 179 days. 181 days. He actually blew the statute of limitations, and he filed the charges, and he had a warrant issue for my client's arrest. So my client, on a charge that he never could have gone to jail for in the first place, was then arrested, taken to jail, and spent an entire weekend in jail for a case that was ultimately dismissed because it was filed outside of the limitations period. So yeah, I think there can be legitimate investigatory angles to holding off on filed charges. There can also be nefarious reasons for holding off on filing charges.
I mean, hey, look, I've said it again and again. If you have a criminal issue and you think you can take care of it yourself, or you think it's easy, I would beg you to give the law office of Brian Jones a call, because these strategies are well known by Brian and his team, but maybe not so much by you yourself, not having all the experience that they have and the training. And so I guess we'll move on to just one quick definition. Like, what is the paraphernalia that you're talking about that would result in a criminal charge?
So paraphernalia is one of those really broadly defined terms in the law. So specifically, it's the equivalent needed to engage in a particular activity. So a marijuana pipe, needles, syringes, a water pipe, or a bong, as most people refer to them as. All of these devices are used to ingest controlled substances. Now, the charge and whether it can stick depends not only on what the paraphernalia is, what the item itself is, but also the context within which it's found. Because items like spoons, Brillo pads, and soda cans can also be charged as paraphernalia, even though you have a completely legitimate right to have a spoon or a scrubbing pad or an empty can of soda in your car. But if those are in the right context, and if the officer can put that context into evidence, the spoon was burnt on the bottom and had residue on it. The soda can was crushed in and had holes poked in it and had some burn marks on it. Now that soda can becomes a marijuana consumption device. Now that spoon becomes a device for the preparation of heroin for injection. Items like that you may have an absolute lawful right to possess can become the subject of a criminal charge if the officer interprets the context of the situation as supporting an inference that the item is being used to consume an illegal substance.
Well, that is good to know, and looking forward to hearing what we're diving into next week. This is certainly a word of warning to those listening. Be careful about what you have in your car.
Absolutely, and be careful about the context within which you have it. Erica, thank you. I appreciate you engaging in this discussion with me, and everybody out there for listening. Thank you as well. To stay informed about the big stories in local and national criminal injustice system news, police and government accountability, searches, seizures, and all your constitutional and civil rights, look to the law office of brianjones.com or find us on Facebook at facebook.com/Central Ohio Criminal Defense. Look to us on Twitter, Instagram, and TikTok at TLOBJ. And we'll be back next week with a sui generis perspective on the next big thing in civil rights and criminal injustice system news, as well as a deep dive into interlock devices, the industry, and how they monitor alcohol use by people who are driving cars. Erica, my grandfather always said when we parted ways, "Hey kid, don't do anything I wouldn't do." And to that, I add when I part ways with my friends, if you do and you get caught, call me. I'll defend your rights as I'd want mine defended.